SJC-12761, Robert Goreham v. Rose Martins.
Mr. Muccio, good morning.
Good morning, Your Honor. My name is Louis J. Muccio, and along with Jared J. Muccio, we represent Robert Goreham. We are asking this court to reverse the decision of the trial court for two primary reasons. Having determined that the driveway at issue on which Mr. Goreham fell was vital to the use of the premises, it was logically inconsistent for the court then to conclude that that driveway was somehow misused by Mr. Goreham. Additionally, it's clear that the trial court misapplied the products liability doctrine from Correa by not establishing that Mr. Goreham's use of the rear stairway to access the driveway was unintended, unforeseen, and unreasonable. Now, it's important, there's facts in this case which are essential to the court's analysis. And one of the most important facts is that the driveway was the only egress path from the building to the street. In the record appendix, there are photographs of the premises. There was no front entrance.
I saw that. I didn't see the front entrance.
There was no front entrance.
There's no front entrance?
There was no front entrance.
So when they say were they all going out the fire escape?
The record establishes that Mr. Goreham resided from 2003, 10 years before the incident. He would park his car at the rear of the premises, and he would access his apartment through a rear entrance, right, which is
Go ahead.
And that would enable him to enter his apartment directly from the rear egress.
Now, I saw a photo, and it looked like it was a stone wall with something behind it, and looking like you could come down two sides. What was that? Was that a side entrance? Is there a side entrance?
There's a reference to in my brief, it's a side entrance.
A side entrance.
And
where does that lead you?
The side entrance abuts the driveway.
So, but there's no front entrance at all in this building?
The building is configured, it's a rectangle, and the side of the building abuts the public way. The front of the building, which is where the side entrance is, abuts the driveway. So,
okay, I get it.
So are you saying it really, the issue of that there's no parking in the tenancy really is not...
It's immaterial.
Your position is it's just not material to this discussion.
It's totally immaterial. Plus, I believe in the record appendix, there is a tenant at will agreement, and in there it says parking is permitted in one spot. So he parked there for 7 years.
So just to get this straight in my mind, as far as the implied warranty of habitability only applying to the premises, you're saying, no, we are dealing with the condition of the premises, and worrying about whether it was parking in the driveway is not really the issue, because that's how you get out of the apartment. Is that what you're saying?
The only way to reach the public way is to traverse the driveway. That is the only egress path.
So you're saying it was irrelevant that it was from the fire escape as opposed to the side entrance?
I'm sorry?
It was irrelevant that it was from the fire escape rather than from the side entrance that he left?
Well, it's irrelevant in that the defect at issue here was on the icy driveway. So whether you exit the apartment from the rear entrance, as Mr. Gorman did, or from the side entrance, which he never, ever, ever used.
But you could use it. You could use the side entrance.
He could, but for
Okay, but my point is that if he had used the side entrance, where on the driveway would he have been? Would he have been past the defect?
He would have been on the defect. The record establishes that the driveway was 80% covered with snow. He fell within 4 feet of the sidewalk. So whether he...
Of the sidewalk?
Of the sidewalk.
Okay.
So whether he used the side entrance or the rear entrance,
Oh,
he
it's
would've
irrelevant,
faced-
it's immaterial, in other words.
He had the same defect.
So really, the only question we have to answer is whether that driveway comes within the warranty of habitability, is that right?
And I
Don't have
believe,
to worry about misuse of the premises or any of those things, because
Well, I think
all
it's-
roads lead to the ice.
all
All exits
paths
lead-
lead
yes.
across the icy driveway, whether he used the rear or whether he used the side. And an important fact is, he lived there for 7 years.
But you're not bringing a tort, you're bringing a breach of the warranty of habitability and the breach of the covenant of quiet enjoyment, right? Those are the two, we have to, as a preliminary matter, decide whether a driveway is covered by the warranty of habitability or the covenant of quiet enjoyment, right? Or you lose if we don't, we can't skip that step, right? And that's
Vitality.
And that's like a giant step for mankind or not? Or is that a tiny step?
No, well, we're dealing with the implied warrant, have a common law doctrine.
But let me, and I don't mean to cut you off, and I'm going to, but warranty of habitability, have we applied the warranty of habitability to driveways? Have other states applied the warranty of habitability to driveways?
I could find no case with similar facts.
That's an interesting
But we have-
problem, isn't it?
But, well,
Because, I mean, I think of habitability, I don't sleep on my driveway. The covenant of quiet enjoyment seems like a different issue, and maybe more apropos of a driveway, but is this warranty of habitability even applicable here?
certainly is.
Why?
Well, because what we're dealing with, we're dealing with a common law doctrine. And the way,
But we have tort suits covering that driveway. If they negligently maintain that driveway, there's a clear avenue to pursue that. You're extending it into a different area of the law. Isn't that a significant extension of the law?
I don't believe I'm extending it all, because under the evolving case law which interprets the warranty, it is clearly extended to common areas.
But Mr. Muscio, we're talking about, I mean, we've got the New Bedford Housing Authority case, we've got the Berman and Son case, we've got all these cases that are talking about defects to the property itself, physical facilities vital to the leased property, and this is a driveway. No one's saying that if there's a defective driveway, that your client, if your client can show negligence, shouldn't succeed in the lawsuit. It's just under what cause of action?
As I understand the defense argument and the court's concern, extending it to the driveway would go too far. So under that analysis, if the warranty applies to the rear exterior stairway, which is defective and covered with snow, and doesn't apply to the step on the driveway, which is also covered with snow, it's a distinction without a difference. It's all part and parcel, integral to the premises.
Is this getting back to your egress point that would be
Yes.
covered by the building
It's an
code?
egress point, again.
Which is covered by the building
And
code.
again, why this should be limited, we are dealing with, in this case, an egress path. There was no other means to leave the structure unless you cross the driveway. And can I finish that point? So when you step off the stairway onto that hazardous driveway, you face the same hazard and risk that you would have had if you were on a step which was defective, which is part of the structure. So limiting it to the structure, I suggest, is a distinction without a difference. What we're talking about is a hazard here.
Well,
A
there's a big
hazard
difference.
under
One
the
might involve
I'm
comparative
sorry.
negligence, one might not.
I'm sorry?
It's a big difference of whether it covers that next step as to whether or not there's comparative negligence, isn't it?
Well, and again, what I suggest to the panel is habitability, which is where this started in Hemingway and its progeny, is a lot different than the concept of vitality. Because that's and that's a much broader concept. There's a recent case that, as a matter of fact, my brother cited in his brief, and it's on page 26, and it's Clark versus Leisure Woods, and it's a 2016 case. And in that case, the housing court applied the warranty to streets in a mobile home park. The people rented trailers, they also rented the contiguous property. In that case, the housing court found, and the appeals court affirmed, that the warranty extended to the failure to remove snow and ice on the contiguous ways. So the application here is limited. We've got an egress path, which is vital. He can't cross that.
Right.
He can't get to the street.
Let me ask you a question. Your brother argues that Doe limits the principles, Doe versus New Bedford housing. That was involving people hanging around the house, right?
Unlawful criminal
Unlawful
activity.
criminal activity.
And the distinction there, I don't mean to interrupt you.
No,
That
that's what
was
I'm looking
for,
for.
and I think the ruling regarding non-applicability was because it was a non-physical defect. That was the
Well,
language as I.
arguably, isn't the snow and ice like the criminal activity hanging around the house?
Absolutely not. It's an.
Feels
it's-
like it to me sometimes.
Well, yeah, I mean, that's another issue. Applying the reasoning of the trial court, the reasoning of the trial court would make any of us an unreasonable user anytime we step on snow and ice.
Right.
And again, what we're suggesting here is there's not a broad expansion of the warranty to limit it to these facts.
Well, let's pursue that, because the warranty of habitability does not require a finding of negligence, correct?
Correct, Your Honor.
By the way, before we go too far, the home was the grayish home or the bluish home in the background?
I can't hear you.
In the photos, I see a light bluish home and a grayish home. Is the home at issue the grayish home? In the photos, I'm trying to figure out which driveway is they're photographing. I gather it's the dark brown or dark gray house?
The premises at issue is the blue house.
Oh, it's the blue house.
And
It's
the
it's the
driveway
light blue.
at issue, and this is the reference to the side stairway, they both empty onto the hazardous driveway.
This is on page 320, it's the light blue.
320 are, yes.
Gotcha, okay. So, Tuesday morning, it snows. There's ice on a driveway. Is there a breach of the warranty of habitability on Tuesday morning where there wasn't on Sunday?
It depends where it is.
It's on the driveway. So it's everywhere, it snows.
Depends how much there is.
Lot.
It's the same as,
lot.
your case. It's just on a different day.
It's a lot. So are you saying that every time there is snow, there's a lot of snow on a driveway, there's a breach of the warranty of habitability?
I am saying it depends on the configuration of the property and whether I guess a factual determination has to be made on a case-by-case basis as to whether the component of the premises, be it a driveway or a sidewalk, is vital. And I think that's the focus.
Let's assume it is. Let's assume, put aside that part. Let's assume that there's 12 inches of snow that lands on the sidewalk. It's the only egress. Is there, on the day of the snowstorm, a breach of the warranty of habitability?
There could be.
There could be, based on what? Is there any finding of negligence that you're assuming? Negligence on the part of the owner to not clear it? Or are you trying to weave in negligence to the breach of the warranty of habitability where before it never existed?
Well, in this case, the jury made a finding of negligence.
Okay, I understand that, but I'm asking if you're trying to incorporate a lot of snow and ice and saying that's within the realm of the breach of the warranty of habitability, are you saying that we should weave in a negligence requirement to the breach of warranty, which we've never done before?
What I'm suggesting is on the facts of this case, as found by this judge who heard the evidence, listened to the witnesses, his determination that the driveway in this specific case was vital to the use of the premises under these facts is not wrong.
Okay,
And
but
I guess
that means that every time there's a heavy snowstorm, which is going to mean that during the course of the snowstorm, it's going to be dangerous for the person to walk. There's a breach of the breach of the warranty of habitability that every owner in Massachusetts has now invoked because there's snow and ice that could be dangerous on the walkway.
I'm not suggesting that. I'm
How are
suggesting
you not?
it-
How do you get around that?
it's a fact-specific inquiry,
But I
Your
mean,
Honor.
but let's assume it's, we're talking about, I mean, you're speaking about, the fact you're speaking about is the egress. The snow lands everywhere, including on the sidewalk leaving from every rental apartment. So are you saying that for every time that it snows and blocks or makes it dangerous to walk out of a rental apartment, there's a breach of the warranty of habitability?
I'm not saying that.
Okay, so when is there?
When there's a factual determination that egress is essential to the use of it doesn't apply in every
I'm
case.
telling you that in my example, it's essential. It snows on every egress from every rental apartment. The snow does not discriminate. So put aside, the egress can't be what distinguishes it. I mean, of course, it snows everywhere.
And of course, everywhere you have to egress.
Well, in this case, your only egress was across the hazardous driveway.
But when it snows, you've got to egress somewhere, right? Those of us who have to come to work have to leave our house.
The weather has nothing to do with the condition of the apartment.
Well, that's a distinction as to whether the warranty applies to the physical structure. And again,
That's what I'm asking about. That's
And
the
I say
issue.
it doesn't. And the Doe case is instructive. In the Doe case, they said it didn't apply because it was a non-physical defect. In the same case, however, they said it applied to the covenant of quiet enjoyment. And again, it's a non-physical defect. Again, as I read the case law,
But in that case, you couldn't, basically, again, I may be misremembering the facts. That's the danger, you've got criminals running around. Doesn't matter if it's raining or not, you're always in danger of, and so you can't enjoy your home no matter what the conditions because it's too dangerous to leave. It's a little different than it's too dangerous to leave because it snowed, right? I mean, that's why I really worry that you're taking concepts and moving them to places they don't belong.
Can you address the amicus arguments about the restatement?
in terms of it being a negligence standard.
Does that help you, or does that
I guess
hurt you?
I'd go back to Scott versus Garfield, because as I read Scott versus Garfield, at least the decision, in that case, there was I believe a guest of a tenant fell from a porch. And in that case, this court expanded the warranty of habitability so it would apply to guests as well as tenants. And I believe there was a finding in that case of negligence, and there was also a finding that there was a breach of the warranty of habitability. But because of that finding, the verdict was not reduced for comparative negligence. And
But that makes sense, because a porch is part of the structure, you live in it. And if the porch wasn't breaching the warranty of habitability because it got snow on it, it's because it was defective and the person fell off of it, right? That seems to be a classic warranty of habitability issue.
Yeah.
But in Krell versus McCafferty, there was a injury in a porch that was not rented to the tenant, not part of his demise premises. And that's where this court first enunciated the principle of vitality. So even though it's not part of the rental premises, it was still within the ambit of the warranty. So I understand this court's concern about the proverbial public policy opening the floodgate arguments, but here the facts are very unique and very specific. And, moving forward, For the warranty to extend, it would have to be very, very fact-specific. And again, it's not really a habitability analysis. As I understand the evolving case law, it's a vitality analysis, which is on a case-by-case basis.
All right, thank you.
Thank you.
Mr. Kober.
Good morning. Peter Kober for the defendants, Rose Martins and the late Jose Martins. I would like to address, before I really get into the issue of habitability and quiet enjoyment, a factual matter that was just raised. And that is that the testimony of the plaintiff was that he chose not to take the front entrance. And the front entrance does lead to a sidewalk, and one end of the sidewalk leads to the driveway.
And when you say front entrance, we're talking about that side thing?
Side
right?
entrance,
Okay,
yes,
Just the front side entrance,
Yeah.
got it.
It was referred to, I think, as the front entrance in the testimony, but side of the building. The other side of the sidewalk basically led to the sidewalk in front of the house.
So it doesn't, the egress is not only to the driveway, in other words?
Precisely. So there was a safe way to go. It was not necessary for him to walk across the driveway. And certainly he could have also chosen to drive, which he didn't do. He had driven safely into the parking space. He had walked safely from the parking space to the rear fire exit. He chose not to do that. He could have simply waited until the snow and the rain stopped. He chose not to do that. He could have worn something better by way of footwear than a pair of sneakers out in the snow. He chose not to do that. So there were other options for him. That, I suggest, was probably the finding, the basis of the finding of comparative negligence on his part. But in any event, there was this separate egress which he chose not to take. Now, as far as the issue of the applicability of the warranty of habitability, Justice Kafker, I think you hit the nail on the head. What we are talking about, in a sense, is a square peg for a round hole. Warranty of habitability has been applied to personal injury cases. It generally, however, relates to issues of rent abatement, rent payment, things of that nature. The amicus brief talks about the other states that have addressed the issue of comparative negligence and prominently talk about the Peterson case out in California, which found that comparative negligence was a more appropriate standard to be followed in cases involving breach of warranty of habitability. And the Peterson case overruled the Becker case, which was 10 years earlier, in large part because during the interim period, other states had looked at the issue and had unanimously decided to adopt a negligence standard. There was also apparently some lower courts in California that were sub rosa following a negligence standard, and the restatement clearly indicated that a negligence standard was appropriate. So I would respectfully submit that to the extent that this court would be inclined to consider that issue, and I'm not saying that you have to, because I think the facts of this case stand on their own, I think a comparative negligence standard is probably the
Well, if a
appropriate.
comparative negligence standard applies, then the negligence standard applies.
I'm sorry?
If a comparative negligence standard applies, then a negligence standard applies.
Correct.
Which means that the landlord would have to have reasonably have knowledge of what is a condition in the premises that makes it uninhabitable,
Correct.
which would be a considerable limitation on the scope of a renter's rights right now.
Well, the renter would still have a negligence claim.
Right, but negligence claim requires that there be reasonable notice to the landlord to fix, and right now, that's not required, and that is a huge difference in terms of the balance of power between a tenant and a landlord.
Correct. And that's why I argued that in the context of a snow and ice case, it really doesn't make a great deal of sense because, for example, the statute that relates to prejudicial notice would basically go out the window. And the comparative negligence standard would basically go out the window. I think there's something else that's important.
But if it's snowing in his house, we don't look at, I mean, inside the house, we would have a violation of the warranty of habitability, whether he's negligent or not, right?
Correct.
So,
But that would be a violation presumably of the sanitary code and the building code.
but it would also be, we don't apply, in conventional rent cases, we don't apply a negligence standard to the breach of warranty of habitability, do we?
No.
So don't we have to decide the preliminary question whether the driveways are outside of the scope of this? Because you're starting to mix and match just the way he would. You like certain things, you want to incorporate them, but the concepts are getting blurred in a way that's going to cause a lot of problems, because we don't want to have a negligence standard for problems inside the house.
No, because those relate, as my brother said, to whether, what is it that's vital to living in the house? What is it that makes the house habitable? Obviously, if there's snow coming into the house itself, the house presumably isn't habitable.
So let me take this, particularly I'm worried about the covenant of quiet enjoyment.
Yes.
If you have a giant trench in your driveway, you've created this dangerous setup in the driveway and in the sidewalk around the house, that could violate the covenant of quiet enjoyment, right? You can't get out of the house easily without having to scramble. Forget about the snow.
Okay.
So the covenant of quiet enjoyment could apply into this area we're talking about, right?
Well, I suppose theoretically, although there you would probably have a violation of certain regulations or
But you couldn't
perhaps
enjoy
even
your
a
home.
statute.
Couldn't enjoy your home if you couldn't get out of it every day, right?
I think that's true, and that's the Doe case. The criminal element was such that the court found that the issue really was whether people were trapped. These inhabitants of the housing project were basically trapped and couldn't go outside. They couldn't enjoy the parks. They couldn't enjoy any of the common areas. And so this adversely impacted on their ability to enjoy the premises. And I think it's also important to understand, I mean, it isn't just a matter of enjoyment, but it's a matter of the value of the premises. And the case law talks specifically about interference with the value of the premises. Now, I think the trench is, in fact, a good example, but I think the problem with the trench, which makes it impossible to get out, is that it is a violation of presumably the sanitary code or the building code.
Well, it may be a violation of the covenant of quiet enjoyment. I mean, right?
Well,
I don't know, but
I
it's just,
suppose.
I'm just trying to figure out what box we should be putting all these things in. You guys are both moving around the boxes all over the place.
Well, lawyers tend to do that, unfortunately. I think part of the problem, though, is quiet enjoyment is kind of an amorphous issue, where you're talking about the enjoyment of one's premises.
But do we eliminate all of this by combining the fact that snow, this is snow, the covenant, neither the covenant of quiet enjoyment or warranty of habitability are implicated by snowstorms outside the
dwelling.
Is that the end of the case?
I think so. I think so. And that is the first argument that I made, both in the context of the warranty of habitability and the quiet enjoyment.
It's important to say, though, it's the end of this case, but it's not the end of a person's right to be able to go out and walk safely where you can show negligence. It's just you bring the claim under cause of action for negligence.
Correct. You're not going to be wiping out all of those personal injury cases at all. And I think
what's happened here is because there's comparative negligence and you lose on that, we're starting to try to backfill into these other concepts, but it's causing a lot of headaches and may hurt rights for other, for.
Well, I think what's significant about this case and what may ultimately distinguish this case from the other cases that involved breach of warranty of habitability, and I particularly have the Scott case in mind, the amount of negligence on the part of the plaintiff was greater than the amount of negligence of the two defendants put together. If you read the Coulter versus Barbara Green case, which is a product liability case, it talks about and I talked about it on page 30 of my brief. The plaintiff's conduct is not viewed as the sole proximate cause of the injury and does not bar recovery completely unless the plaintiff is more than 50% responsible for his or her injuries. I think the converse of that is that if the plaintiff is more than 50% negligent, if the plaintiff is the one that really is responsible, then breach of warranty shouldn't apply. At least that's how I read the Coulter case. I think it's important that in the Scott case, for example, there was a finding of breach of warranty. There was a finding of comparative negligence, but only 10% on the part of the plaintiff. If you look at most of the cases, they don't talk about comparative negligence because there apparently was no jury finding of comparative negligence.
But let's get back to the breach of the covenant of quiet enjoyment.
Yes.
That does require a finding of negligence on the part of the landlord, I gather.
It does, some negligence.
Do we have any case law as to whether comparative negligence has been applied with regard to a breach of the covenant?
We do not.
We do not. So we would, if we find that there's a breach of the covenant of quiet enjoyment, we would need to decide whether comparative negligence applies.
Correct.
And I should know this, but if a tenant says there's a breach of the covenant of quiet enjoyment because he can't get out of his house because the snow is mounted up and the landlord hasn't cleared it, is that a basis for not paying rent? Well, let me step back. Is a breach of the covenant of quiet enjoyment a ground to not pay rent, a permissible ground to withhold rent?
I believe under the statute, we're talking about 186, Section 14, there are different remedies which are available. And the remedies, I believe, include either reimbursement of rent already paid or rent abatement.
Okay, so going back to Justice Kafker's point, if there were, we'll use snow, let's assume the landlord was totally derelict in failing to clear egresses and meant that every time the person leaves his or her home, he's at risk of his or her life. Could that be a breach of the covenant of quiet enjoyment?
Well, those facts are not the facts here.
Okay, I understand that you claim they're not, but answer my question.
Of course. I think that probably could be. I think that probably should be. I think what's significant in that scenario, though, is that there probably isn't going to be any basis for comparative negligence if he can't even get out of can't even exit the dwelling.
And that,
I think that's significantly different from
so
here.
we would need then to decide, because I think the judge or the jury here found a breach of the covenant of quiet enjoyment, did they not?
No, he did not. He did not find a breach of the covenant of quiet enjoyment.
So how is that in the case then?
Well, I think what my brother has argued is because there was a finding of negligence, that automatically there should be a finding of
Now, you know what, I have a question I should know the answer to, and but I just don't get a very basic thing about this case. So there's a jury,
Yes.
and there's a negligence determination, but the negligence of the plaintiff exceeds the negligence of the defendant, so there's no recovery. And then after that, Judge Kerman writes a decision on the breach of warranty of quiet enjoyment and habitability. Why is it that those claims don't go to the jury?
Actually, I think we talked about that before impanelment. And he had indicated he was going to reserve those issues to himself.
There's no right to a jury trial for those type of claims?
I don't know whether there is a right to
A
a jury.
weird procedural posture in this case.
Well, it was a bit of a head scratcher, I think, for all of us.
And that's why you got the plaintiff more than 50% negligent and now attempts to chisel into existing doctrines.
Right.
All right.
Back to the chief's question, though. He did find there was fault, but he found that comparative negligence overrode the right to recover for quiet enjoyment. So
Correct.
So we might have to revisit that. If we don't believe comparative negligence applies to the covenant of quiet enjoyment, we might have to reverse that part of this, right?
Well, again, I go back to what I had said before, which is this situation is, if not unique, it's somewhat different than a lot of other ones, in the sense that you have a negligence case where the comparative negligence is found as a matter of fact by the jury to exceed the negligence of the defendants. And I think that might be a way to draw the line in future cases. It doesn't have to be drawn in cases where you're talking about rent abatement or rent reimbursement or something like that. But I think for purposes of personal injury cases, it probably makes a great deal of sense. Just as I think it makes a great deal of sense in the context of the warranty of habitability.
But isn't there another problem with the quiet enjoyment analysis, which is this is just one day of snow, right? Don't you, in order to, I mean, the chief posed the where you have dereliction of snow, I mean, if this goes on all January and all February.
Right.
But here we have just the first day of snow. Can you violate the covenant of quiet enjoyment on right after it snows?
Well, I think that's a serious problem. I think that's a serious problem. And I think, again, presumably in the context of personal injuries, it makes no sense whatsoever. as an aside, I would mention this happened to be a winter in which there was testimony that it snowed all the time. And so there were issues about, and there was conflicting testimony about whether the snow was, whether the snow was cleared away or not. The testimony of the other tenant, Ms. Katara, was that the snow was cleared away. The testimony of the plaintiff was the snow wasn't cleared
So
away.
is that a disputed fact here about whether there's been a consistent violation of the cleanup requirement, consistent failure to clean that driveway, so that we may be in the issue of covenant of good, quiet enjoyment?
Well, that was a disputed issue of fact. I would say it was sharply disputed. In addition to the tenant, there was also testimony from the other defendant, Mr. Albert Martins, who testified that the snow was cleared properly, and from his employee, Jose de Cruz, who testified that the snow was cleared properly. So I would submit that this is not clear-cut at all, that there was dereliction of cleaning up the snow.
Was there any finding that there was a serious interference with the loss of enjoyment of property?
No, that was never submitted to the jury.
So do we have any finding of a breach of the covenant of quiet enjoyment apart from the judge's reference to it in the comparative negligence context?
No finding. I would submit the evidence was such that there would be no basis on which to find a breach of the covenant of quiet enjoyment.
And is that a matter, going back to Justice Lowy's question, is that a matter for the judge or for the jury?
Well, I think historically it has been decided in a number of cases by the jury. I'm not aware that the statute provides that this is something that has to be decided by a jury, and I'm not aware of any case law that says that that has to be decided by a jury. Similarly, in the case of, I would mention in the case of Spalding versus Young, there was a finding of negligence on the part of the landlord. And if you recall, this was the case in which the kitchen cabinet apparently fell on the tenant. And the judge apparently reserved to himself the issue of warranty of habitability and found that there was no breach of the warranty of habitability, notwithstanding that there was a finding of negligence, and went through a rather detailed reasoning process of why there was no breach, and specifically said no statute was violated, the sanitary code wasn't violated, building code wasn't violated, the Board of Health wasn't notified. All of these things are present in this case. And I would respectfully submit this case is on all fours in that sense with the Spalding case.
Okay, thank you.
Thank you.
We will take our morning break.